It's Kathy. Hope you're doing well. We made it to OJ. And the trash is out. All right. Make sure our speed is correct. Yesterday, when I was pressing this little loopy thing, it was not staying. When it started the new video, it stopped playing the shuffle. So, hold on. Let me just think what that means for today, because we have, this video is an hour and 58. Okay, we're fine. Once this flips over in another 20 minutes, we won't have another video flip over. So I won't be driving and you guys watch the screen and nothing happened.
Now, finally, you have continued testing. Are you still continuing testing in this case?
Well, as I mentioned, there is another autorad that I'd like to look at this afternoon, another probe, another one of these autorads that we're developing.
Have you tested item 1, the speck on the door that was first observed by Detective Furman?
Sustained.
Do you have DNA samples from the handrail? Have you tested that?
Sustained.
Excuse me for 1 second. Approach the bench for just 1 minute.
Scope. Proceed.
On the scope, I want to ask a question.
All right, with the corporate.
Take just a second.
It's a different board. I know we saw OJ's Bronco before, but I don't remember this. Wait, do I? It's the picture in the middle that's getting me. I don't remember the circle picture in the middle.
All right, thank you, counsel. Proceed.
Now, Mr. Harmon asked you some questions on direct examination about these RFLP results, allaying concerns that Dr. Gerdes expressed with respect to cross-contamination. You recall that?
Yes,
He asked you that question very generally, didn't he?
yes.
Now, these RFLP results only deal with samples 303, 304, and 305.
That's correct.
These RFLP results do not address any issues of cross-contamination with respect to the Blundy blood drops 47, 48, 49, 50, and 52.
Objection that's made, Your Honor.
Overruled.
No, these results relate to these samples.
All right? They don't relate to any problems of cross-contamination that occurred in the evidence processing room on June 14th when Colin Yamauchi examined the Rockingham glove.
Objection is beyond scope.
Overruled. But you can generalize this.
I just only have 2 or 3 more questions just to show what it doesn't concern.
It also misstates the testimony.
Overruled.
The question again,
The
please.
question is, these RFLP results don't address the issues of cross-contamination that have been raised by Dr. Gerdes concerning Colin Yamauchi's handling of the Rockingham glove in the evidence processing room on the morning of June 14th, right?
I'm trying to recall what issues Dr. Gerdes specifically raised about those, because I don't recall seeing any issue with those particular samples.
Well, you don't recall his testimony about that? Is that what you're telling us?
I don't recall the details of his testimony about those particular samples.
You don't recall his testimony about Mr. Yamauchi? All right. You don't recall it? Is that what your
Well, I said I
testimony?
don't recall all the details. When you start talking about issues, you're putting a plural on it, and you're
Mr. Sims.
implying there's some
Mr. Sims, even if you can't recall all the details of what Dr. Gertie said, you don't believe that these RFLP results on 303, 304, and 305 have anything to do with it?
Objection, it's argument.
It is.
Do you believe they have anything to do with it? Do
Well-
they address those concerns about cross-contamination?
I think in the narrow sense of your question, no. The answer is no, they don't address that.
Thank you. Now, Dr. Gerties gave extensive testimony concerning a study he performed.
As a person, I just would not buy the theatrics if I was on the jury. Like, I just think the way he questions people would just annoy me so much that it would be counterproductive. He would not get his point across with me. It just wouldn't happen.
Of contamination at the LAPD laboratory and the efficacy of controls and sample handling procedures used at the LAPD laboratory. You're familiar with the fact that he testified about such a study?
Objections beyond the scope of the record.
My last question in this line.
Yes, I'm aware that he presented that.
You didn't read that study or review his data, did you?
No, I did not.
Now, Your Honor, and we just think about it, but I actually think I'm finished. Your Honor, I have no further questions, but I would request, based on what we've discussed, that this witness be subject to recall on another matter.
All right, no, Mr. Sims, we know where Mr. Sims is, and he knows how to get to L.A. All right. Mr. Harmon, do you have any redirect examination for Mr. Sims?
Just taking up with that last point, Dr. Gertie's study about LAPD, do you recall that Dr. Gertie's was unable to recount the history of from the sample collection of 303, 304, and 305 when Mr. Clark asked him to recite that to the jury?
So far as he said he doesn't remember his testimony completely.
Oh, well.
No, I did read that part of the testimony. I did review that
That's not what he
particular part of the
said
testimony
at
regarding
all.
who collected the sample.
He said he didn't memorize all the details. He didn't say he doesn't remember the testimony.
On with regards to 303, 304, and 305.
And based on reviewing his testimony, do you recall that Dr. Gertie's made no specific technical criticisms of your PCR results from 303, 304, and 305?
Yes, my recollection in his transcript was that there was no specific criticism of those PCR results.
Now, Mr. Sims, your crime scene collection days have long passed, is that right?
I haven't been to a crime scene or a vehicle, that sort of thing, in about 5 years now, over
And
5 years.
Mr. Scheck asked you about the appropriate way to preserve evidence and keep logs of who has access to evidence. You recall that?
Yes.
Now, and you said that's not the appropriate way to do it.
Well, I just said that access should be controlled. I think that was the gist of my
Now,
response.
the failure to keep a log of who went in and out of a car, if anyone went in and out of the car, that's not going to change the types of the RFLP results that you presented to this jury that are consistent with Mr. Simpson and Mr. Goldman, is it?
Beyond scope calls for speculation.
Oh, well.
No.
And allowing people to go into the car to look around, unauthorized people, if that actually happened, that alone is not going to necessarily change the PCR or RFLP results from 303, 304, and 305, is it?
That's correct.
What you have presented to this jury is the results of your testing, DNA testing from various samples that are provided to you. Is that true?
Yes.
Is it unusual for you not to know the history of a sample in a case?
No, it's not unusual to not know the complete history of a sample in a case.
In fact, given the way these violent crimes often occur, some history of the sample is frequently lacking when you do your testing. Isn't that correct?
Well, yes, that's true.
Let's just I'll give you a hypothetical and so we can illustrate this. Let's assume we have a female brutally murdered, signs of sexual assault,
Objection. Calls for speculation irrelevant beyond the scope.
Oh, well.
signs of sexual assault, evidences of vaginal swabs, parents' seminal stains on clothing are all collected and sent to you with reference samples. Are
Renew
you
the
with me so
objection on
far?
relevancy grounds.
Oh, well. Haven't
Yes.
heard the question yet.
Now, that's not an unusual case to be presented to you in the DOJ lab, is it? Evidence like that?
No, that would be a typical or not unusual.
And it's not unusual for you to perform tests on those samples, isn't that true?
Yes,
And in cases like that, you have frequently identified people as the source of sperm in apparent sexual assault murder cases, isn't that true?
yes. For example, we've used the DNA to say who could be a potential source of that particular semen sample.
Now, when you do those testing, or that testing, based on the test results alone, you can't necessarily tell whether the sex act that produced the sperm occurred before the homicide, can you?
That's correct.
You can't necessarily tell that the sex act that produced the sperm occurred during the homicide.
We're about to become irrelevant.
About 2 more questions, they'll be totally irrelevant, Your Honor. You can't tell that the sex act that produced the sperm occurred in any relationship to the violence that caused the homicide, can you?
That's correct.
And last question on this point. You can, for example, you might be identified, or the sperm that you produce might be someone who had sex with a person who's been murdered where the sex act occurred after the homicide.
Possible.
All right, let's move on.
Now, Mr. Schecht asked you a series of questions about people having access to the car and coming into the car, and I just asked you some questions about those things wouldn't necessarily change the type of the result of the DNA that was there. Do you recall that?
Yes.
Now, in order for one person to have produced the RFLP results or the PCR results that you detected on that console, there'd have to be something terribly wrong with that person, wouldn't there?
Objection. Vague.
Sustain. Vague.
Based on your DNA results, in order for one person to account for the DNA results from 303, 304, 305, both individually and in combination, there'd have to be something terribly wrong with that person, wouldn't there?
Sustain.
Would there have to be something terribly wrong from one person if one person were to try to account for all of the results from 303, 304, and 305?
Or
Yes, it would be some sort of genetic anomaly.
In what sense?
Well, because you see more what we call alleles or types than you would from a single individual.
Okay. For example, you've already described the significance of seeing 4 bands, 2 of higher intensity and 2 of lower intensity.
Yes.
Are you aware of anything in the literature where one person could have 4 bands where there are different intensities
Well,
from these probes?
the sort of thing where we might see that would be on, for example, somebody who is transfused or something unusual like that.
Well, to just add to the mystery a little bit, if in order for you've paired those results, you've paired some of them that are consistent with Mr. Simpson by relative intensity and some that are weaker than Mr. Simpson, and they're consistent with Mr. Goldman. Is that correct?
Yes, the intensity patterns, the band intensity patterns pair up between those two
I don't feel like
individuals.
standing up.
In order for another person to account for depositing, let's say, the weaker set of bands,
I'll be back,
they'd have
guys.
to match Mr. Goldman's
I'll
type,
be
wouldn't
back
they?
quick.
Yes.
Now, the last point, or I think it's the last point at least, Mr. Schecht asked you about the console mixture results that you've described to this jury, 303, 304, and 305, both PCR and RFLP. And you said they're not inconsistent with 2 deposits, the results alone. Do you recall that?
The RFLP results are consistent with 2 depositors.
I didn't speak clearly enough. Are they, I think you told him they're consistent with 2 separate deposits, having come at 2 different times.
Oh, as far as the order of deposition?
Yeah, or whether they were simultaneous or at different times.
Well, I said I could not rule out that possibility, yes.
Now, is there something about the amounts of DNA in those samples that tells you that it's highly improbable that that occurred?
Well, it's hard to say too much just based on the amounts of DNA in those particular samples. I have no reason to suspect that they are from different times, but there's nothing clear to me one way or the other.
Would you say that the amounts that would be represented from, say, Nicole Brown, who is not detected in the RFLP testing, what can you tell us about that?
Well, when you enter the point now where you're talking about 3 different people's blood on a console in a vehicle, I mean, forensically, that seems very significant to me. I mean, it just seems unusual that you would have 3 different individuals bleeding or their blood present inside a vehicle in that kind of a location. That, to me, is the significance.
May I have a moment, Your Honor? Mr. Sims, Mr. Scheck never asked you about 293. 293, you're aware of the history of 293?
My apologies.
Asked about
293.
293.
Yes, he asked me about that, and I discussed a little bit about how the carpet was cut out and then later sampled.
Okay. And that was done at the earlier date rather than the later date. Is that your recollection?
My understanding is the carpet was cut out at the earlier date.
And the types that you found on the carpet are consistent with are the types that you found on the carpet consistent with what you detect as the possible presence of Nicole Brown on 303, 304, and 305?
Are they consistent? Yes. In other words, her type that was found on that sample is consistent also with what was seen in the Bronco console.
And finally, I'm going to ask you a question about 31 and 30 and 303 and 304 and 305. Get a chance to look at those results? Are those results consistent with Mr. Simpson having injured himself during the brutal murder of Nicole Brown and Ronald Goldman, returning to his car, that Bronco, with a right-handed glove that bore their blood commingled with his blood from his injured left hand, and somehow that item having come in contact with the console?
Objection calls for speculation.
Sustained. Foundation.
I'm going to ask you a question then about whether the question is, are your results consistent with the following scenario? You know what Mr.
Haven't heard the question yet.
You're familiar with the testimony that Mr. Simpson had a cut on his left hand.
Well, I mentioned that I hadn't heard Dr. Bodden specifically talk about that. I'm aware from other issues in this case about the cut on the hand,
On the left hand.
on the left hand, yes.
You know what his DQ alpha type is.
Yes,
You know what his RFLP type is from all the tests that we've done.
yes,
And you're familiar with the fact that the victims in this case, their reference samples were provided to you for typing.
yes,
Okay. You're familiar with your typing results from the glove, number 9.
yes,
Okay.
Overruled.
You're familiar with where all the stains were found on the console. We've just had the photo board up there. Is that right?
yes,
Are the PCR and RFLP results that you produced, your lab produced from the console, are they consistent with Mr. Simpson having injured himself while brutally murdering Nicole Brown and Ronald Goldman?
No foundation.
Sustained.
Are they consistent with Mr. Simpson having injured himself at or about the time someone brutally murdered Ronald Goldman?
Sustained.
Objection and
Sustained.
strike. Ask for
Sustained.
instruction if he persists.
Mr. Sims, let's go back to the same question about the console. Are all of your console DNA test results consistent with the glove, item number 9, having Mr. Simpson's blood on it, that glove being in the Bronco, coming into and having the victim's blood on it as well, and that glove coming into contact with the console and transferring portions of all 3 participants' blood onto the console?
Objection. No foundation.
Sustained.
Calls for speculation.
Mr. Sims. Mr. Sims, you know what the glove results that your lab produced suggest a mixture consistent with Mr. Goldman, Mr. Simpson, and Ms. Brown. Is that correct?
Beyond the scope.
Overruled.
yes,
I want you to assume hypothetically that that glove was brought into that console or into that Bronco, and that glove transferred some of the blood from the glove onto the
Calls for
console.
speculation.
All right, ladies and gentlemen, we're going to take our recess for the morning session at this time. Remember all my admonitions to you. Don't discuss the case amongst yourselves, form any opinions about the case, conduct any deliberations till the matter has been submitted to you. Do not allow anybody to communicate with you with regard to the case as far as the jury is concerned, and counsel will stand in recess until 1 o'clock. Mr. Sims, you may step down. You're to come back at 1 o'clock. All right, we'll stand in recess. The jury is not present. Counsel, when we adjourned, Mr. Sims was on the stand, and Mr. Harmon was asking a hypothetical question regarding the glove results, number 9, being consistent with 304, 303, and 305, and that's where we were.
Your Honor, I think that I would object to any further questions along this lines in terms of Mr. Harmon was asking a series of hypotheticals that plainly go far beyond what's permitted. We're talking about brutal murders and everything else, and not tied to what was raised on the cross-examination, which all I brought out is that it's consistent with that he can't tell what blood was deposited when. That's all I did. I think this is way beyond the scope, and I think it's reached the point now, after all these different questions, where we're way into argument. Hopefully we'll argue this case soon, but I think that these hypotheticals are improper.
Well, frankly, I thought that after he got this answer, well, when you enter the point now where you're talking about 3 different people's blood on a console in a vehicle, I mean, forensically, that seems very significant to me.
You know, Your Honor,
I mean, it just
I
seems...
reconsidered that over the lunch hour.
I mean, it just seems unusual that you would have 3 different individuals bleeding while there's blood present inside a vehicle in that kind of a location. I thought that was going to be the last question and answer.
It probably should have been. I have 2 more, and they have nothing to do with my hypothetical.
You're going to withdraw the hypothetical?
Yes, Your Honor.
Bless you. All right, let's have the jury.
Your Honor, before we call the jury back, I just did want to put on the record that I was down here over the noon hour and did bring the materials, or at least parts of the materials that we have for defense to see, and they wanted to go out and have lunch. I am now leaving to do some other business that we will be prepared to...
Which materials did you bring down?
I brought down the test impressions that were taken on August the 21st, and I brought down certain of the raw materials that are going to be placed on boards, photographs, including photographs of the jeans, photographs of the Bundy walkway that were taken on June the 13th, plus those that were most recently taken, the black and white photographs of various abnormalities in the tiles, and some other photographic materials that would be used to be placed and mounted on boards for the purposes of evidence that would be presented presumably tomorrow morning.
Mr. Scheck?
You have to... I thought that we had an understanding when Mr. Harmon and Mr. Clark were present at the bench that I reiterated the request, which I thought the court granted yesterday, that we would get an opportunity to look at the test impressions, the blown-up photographs, the shirt, and the jeans at one location. I raised this with Mr. Goldberg earlier. I brought it up with the court. I thought the court said that that could be arranged either in the courthouse or at the lab. I went back to Mr. Goldberg. I said, communicated what Your Honor had said to us. I asked him to make that arrangement. He began to do so. Then Ms. Clark turned to him and said, just show him the test impressions. That's it. And then I said, well, Ms. Clark, it's not my understanding of what the judge just indicated and what he previously ordered. And she said, just give him the test impressions, that's it. And Mr. Scheck, I'm not talking to you. Don't even talk to me. I don't talk to you. That's the way this woman works. And she's ordered him to do that. Now, he came down here at 1:45 as we're running downstairs. He pulls out a big packet and he says, take a look at this one, take a look at this one, take a look at this one. And I say, we're going downstairs to eat lunch. Right now we can't do it. Mr. Morton just arrived. A Federal Express package just came in. Now, you know, I've already made my arguments about an opportunity to look at it. We have to have an opportunity to look at the data that they're going to put on, and we're taking the afternoon off because their witnesses just arrived, and it's a civilized, scientific way to proceed. I've requested an opportunity to talk to the witnesses and just make this simple arrangement. It should take an hour or 2 to show us the data. I think that's what's required, and it's civilized. And I just ask that that be done. And if Mr. Goldberg's going to run out the door and we won't be able to see him later in the day and make arrangements for this, and we won't be able to get a hold of him in the office, I think that's wrong.
Your Honor, my understanding of the court's order yesterday, and I think it was pretty clear, is that we were supposed to, over the noon recess, have the test impressions from the 13th and the 31st, excuse me, from the 21st and the 31st in court. We learned that the 21st impressions have been mailed to the court, so I don't know.
Impressions.
Excuse me, the 31st impressions from the jeans and the shirt have been mailed to the court. But I wanted to try to satisfy the court's order by being down here at over the noon recess, and that's what I was trying to do. If counsel didn't have an opportunity to look at them at that time, whether it's legitimate or illegitimate, doesn't make any difference to me. We will try to accommodate them at some later point. The point is that had they wanted to look at them over the noon recess, they could have done so, and I was trying to fulfill the court's order. No one recalls anything other than Mr. Scheck about the court having revisited this issue and now placed an additional requirement on the people that we are responsible for assembling the jeans, the shirt, the test impressions simultaneously at the same place, at the same location. That's a logistical problem that's difficult for us to do that the court did not require us to do. Because that would mean...
Mr. Goldberg, here's our choice. Mr. Morton's here. Mr. Scheck is here. The impressions are here. It would take us an hour to take this evidence, after the jury's been excused, put it in the jury room, let them look at it, and then we can proceed.
Right.
That's the orderly way to do this.
The only problem would be getting the jeans and the shirt here. We'd have to do that, and that would be difficult.
But I suspect it's less than a mile away.
Well, it's a Piper Tech.
Less than a mile away.
Right, but the point is that it needs to be checked out, and I'm not sure that the jury room is really the appropriate environment to be looking at those jeans. And I'm not sure that would be acceptable to Mr. Morton as a forensic scientist.
Well, given the fact that I want this done now, that's where it's going to be.
Okay.
I don't want to delay this trial anymore. Mr. Morton's here. The impression's apparently here. I'm certain Mrs. Robertson could find somebody to call over at LAPD to get Detective Van Etter to check those items out and get them over here. Let's let them look at it. Maybe we can proceed with this testimony today.
I saw them. They've gone out to Bundy to re-examine the scene and look at the various defects in the tiles. And they will, however, be ready first thing in the morning.
All right, so you're not ready to present this at this point in any event, so because your witnesses are in West LA.
Correct.
All right.
Your Honor, we've also communicated along saying we'd like an opportunity to discuss with the witnesses what it is, because just looking at the test impressions and the markings and the pictures, it's hard to link it up if they could provide us with that opportunity.
Right.
Since
I'll let Ms. Clark do that. Evidently, she's going to be putting on these witnesses, and our policy is we always allow the witnesses to decide on their own. We do not make any suggestion one way or the other.
All right.
Can I just also say I don't think it's necessary for the record. In response to Mr. Scheck's contentions about Ms. Clark's statements, she was simply communicating to me that her recollection of the court's orders were not the same as Mr. Scheck, and that the court did not modify its previous order. For the record, we've tried to get along with all the attorneys as amicably as we can.
Yes.
I think the defense has done so as well. There appears to be a little bit of perhaps it's a cultural clash between the California and New York styles. I don't know what it is. But
he was right about Meshuggah.
we have had a little bit of difficulty at times with Mr. Scheck and Mr. Neufeld, and it is simply easier for us to deal with many things on the record than try to sort them out informally. We've had some trouble doing it.
Well, the court's interest is getting this testimony presented tomorrow. And
I
if that
understand
means,
that, and that is our interest as
Right.
well. I just wanted to say that we have had a little bit of difficulty, and we're trying to smooth it out to the extent that we can.
all right, Mrs. Robertson, excuse me. Would you contact either Detective Van Etter or Detective Lang and see if we can get those two items, the shirt, Mr. Goldman's shirt, Mr. Goldman's pants, checked out and brought over here, please?
Good afternoon, Your Honor. I'm from California, and so I can understand this.
No, we're not discussing this anymore.
There's something else I want to bring up.
No.
If he's going to leave, it has to do with one other thing. So we're going to delay the trial.
What is that?
We need him here if we're going to talk about that video. We have some objections to the video. He's not going to be here. It's his video, isn't it?
Handle it.
All right, Ms. Clark,
All right.
handle it.
Just want to make sure he's available.
Okay.
All right.
All right. So everything's clear. The court has received two packages from the FBI. Mr. Burden, my research attorney, is cataloging those items, and then we'll make those available for inspection to counsel. Also, we've received from NBC what appears to be a sealed package of videotapes in response to our discussions yesterday. All right. Also, excuse me. All right. As soon as Mrs. Robertson logs those in, we'll have the opportunity to display those to counsel. The videotapes from NBC. Also, while we were still in recess, Mr. Neufeld advised the court that he had advised the prosecution that apparently there's some objection you're going to withdraw, Mr. Neufeld.
Yes, sir.
Good afternoon.
Good afternoon. What we are prepared to do, Your Honor, is withdraw the objection that the RFLP results for the combination 303, 304, and 305 stains need to be presented in conjunction with the statistic. And the failure to do so is the objection that we are now withdrawing. But it should be very clear, though, that we're not saying that authorizes them to argue to the jury that the true numbers for the significance of that mixture are the solo contributor stains that exist elsewhere, which have been typed as consistent either with Mr. Goldman.
I don't think
or
they
Mr.
would do
Simpson. Right.
Excuse me, Your Honor, I think that's perfectly proper argument if the jury decides in the context of this case that those two stains did come from those people, and there's other information within this case that will allow them to do that. I think the court, upon reflection, will see that if they decide that, and if that information
Well,
is contained
counsel.
elsewhere, then that's a proper point to make to them, and that's a proper conclusion for them to draw.
You're on two things. Number one, we suggested doing this to save a great deal of time. They're going to have somebody come in from Great Britain. We would then have to have Dr. Shields come in to respond to that issue. It looks to me that from the expressions on the jurors' faces now, I mean, whoever has any more witnesses gets these cold stares from the jury, and we're trying to avoid the continuation of that problem. What we're simply saying is they would be precluded from arguing solo frequencies for the other mixtures, and that's why the court made the initial ruling, and that's why Bruce Weir came in here and offered different frequencies for mixtures than the frequencies that are given for solo stains. So if that's been the approach to mixtures throughout this entire proceeding, it would be a distortion of that reality should they be permitted to then argue something completely different for this mixture, which they're not allowed to argue for any of the other mixtures. It just doesn't make any sense.
Just final response. You know, reality has no reason to be mentioned in any of these arguments. These are legal arguments designed to create a reality, okay? We are not conceding that there's any validity to limiting our argument because they're willing to shorten the trial. Whatever you feel is appropriate argument at that time, you'll have to decide that, Your Honor. We have not agreed to anything except if they withdraw their objection, we will not call a statistician. There's no quid pro quo for that, Your Honor. That's their decision. We're happy they want to shorten the trial. But we have not agreed to any concession on any other point. And I think the court will see in the context of the argument.
The problem I have, though, counsel, is that the original proffer to this evidence, this RFLP, was not to offer any statistics, merely to say that it is consistent with the PCR test. That was the offer that I was given, and that was the assumption that I was under when I allowed this evidence.
And nothing I've said, I think, contravenes that
I agree, so far.
Or undermines that. But my point is, I mean, listen to the cross-examination. I was going to ask you to reconsider your ruling in light of the fact that they have conceded by their cross-examination that part of that RFLP pattern is Mr. Simpson's blood. Well, then who else, what other pattern is left there? And if there's information in this record that this jury can use to evaluate how frequently that fainter pattern, which when you subtract Mr. Simpson's out is Mr. Goldman's, then I think not only is it permissible for them to do that, that Ms. Clark can ask them to do that. She may not want to. My only point, because we're not arguing the case now, is to say we're not conceding any issue in light of what you know, that they don't want to see another statistician here. We're delighted about that as well.
All right, I understand that, but you should understand that the court's already made a ruling in this area.
No,
All right.
we remember that.
Okay, all right. Let's have the jury and let's finish Mr. Sims.
So we will not call a statistician.
All right.
Let me indicate while the jury's coming on, Your Honor, we received, these are other charts that were mailed to us from Agent Diedrich, and I want the defense to know that they're here. I want to show it to them as soon as we recess today.
All right. Let's finish Mr. Sims, and then we'll see where we are at that point. What do you have after Sims, by the way?
The video.
And what after that? Diedrich?
That's it. Well, but that would be
Yeah, they'll have rested twice, and
the court has to be before you guys subject to hearings. Also, Your Honor, we have sent a letter to the defense requesting a Stockdale tape because we have declaration from the answering machine company that they no longer have any copy.
All rise.
be seated. All right, let the record reflect that we've been rejoined by all the members of our jury panel. Good afternoon, ladies and gentlemen. Mr. Gary Sims is again on the witness stand undergoing redirect examination by Mr. Harmon. And Mr. Harmon, you may continue.
Good afternoon, ladies and gentlemen. Mr. Sims, just one last point, a couple of questions. Based on the combination of your RFLP and PCR results from 303, 304, and 305, how would you quantify the amount of DNA which produced results consistent with Nicole Brown?
The amount of DNA for that particular component of the mixture would be what I would describe as a trace level of DNA.
Okay. And you recall Mr. Scheck asked you about eliminating or talking about how many different deposits there would have to be, or there might be, to account for the console results from 303, 304, and 305. Do you recall that question?
Yes.
And you said it's possible that there could be more than one deposit that could have produced the combined results that you saw in this case?
Yes.
Now, in light of the trace amount of DNA that you've described is consistent with the results that are consistent with Nicole Brown, you with me so far?
Yes.
And in light of the fact that you found 3 such results, what series of events would have to have happened in order to have, and assuming that Mr. Simpson's blood was there previous to that in all three places,
Okay.
okay? Would you describe the series of events that would have to have occurred to account for the trace amounts from Nicole Brown and the substrate controls from those three samples testing clean?
Calls for speculation, vague.
Sustain.
Can you describe the series of results? Keep my last question in mind. Can you describe the series of results which would have to have occurred in light of the trace amounts of DNA that are consistent with Nicole Brown?
Calls for speculation again.
Sustain.
In order for you to have seen the results that you saw, which include Mr. Simpson's DQ alpha type, and by the way, how would you describe the amount of DNA which produced Mr. Simpson's types as opposed to the trace amounts that produced results consistent with Ms. Brown?
PCR or the RFLP?
In general, on the three console stains, 303, 304, and 305.
Well, I would describe it that there was significantly more DNA consistent with Mr. Simpson than there was with Nicole Brown Simpson sample.
Okay? Now, in order for you to have seen the results that you had, the greater amount of DNA consistent with Mr. Simpson's type and the trace amount of DNA consistent with Ms. Brown's type, and in order for there to have been two deposits, one of Mr. Simpson and then at least one more with a trace amount of Nicole Brown's, would you have to have had that trace amount deposited on all three separate stains and not on the substrate controls?
Yes.
Substrate objection calls for speculation and is mixing two different.
Call roll.
Thanks, Mr. Sims. I have no further questions.
Mr. Scheck.
The answer was yes.
The answer was yes. Okay. Mr. Sims, you don't know who was in the car, who was in the Bronco in the early morning hours of June 13th.
The early morning hours of June 30th? No, I don't know.
Right. You don't know the identities of the contributors to the mixture on the steering wheel.
That's beyond the scope.
No, I don't know.
Has anybody sent you DNA exemplars from police officers to type?
That's beyond the scope.
Sustain.
You don't know who went into the Bronco between June 14th and August 26th.
I don't know.
Thank you. And
Thank you.
Mr. Harmon? But he's subject to recall for the reasons we stated.
All right, Mr. Sims.
Excuse me.
Thank you. Mr. Sims, again, thank you, sir.
Thank you, Your Honor.
Ms. Clark,
We have our next witness ready, Your Honor, but I think the defense...
we need to preview something?
Yes.
All right. All right, ladies and gentlemen, let me ask you to step back into the jury room. I need to preview something before we present the next witness. All right, I take it, Ms. Clark, the next offer from the people is the statement from Thano Paratus under 1202?
Yes.
All right, let's see the edited.
Yeah, before you see it, I think it would help the court if you knew in advance, because I just got to see a little while ago what some of my concerns are, so you can, when you're looking at the page, you can see whether or not they're there. I just think it helps you in deciding this thing rather quickly.
You want a pre-objective before I see it? All right.
Yeah, or at least to tell you the things.
Well,
that
what
you
should
think-
I be looking for?
Okay, thank you. Your Honor, the problem is I don't believe that they followed your instructions of yesterday. Number one, right off the bat, they start referring to a demonstration that he wants to show. Although he doesn't actually show most of the demonstration, he refers to that he's about to. Number two, he then orally describes the experiment that he did, not with Mr. Simpson's blood, but an experiment that he did sometime between the time he drew Mr. Simpson's blood and the time that this tape is made on July 27th. You said no reference to any experiments are to be included in this tape. It's simple impeachment on the issue of the 8 cc's. He goes through a description of the experiment he conducted in his own infirmary 8 months after the incident to help convince him of the error of his ways, that his testimony at the grand jury and preliminary hearing were wrong. So they didn't follow your instructions with regard to that either. Number three, on the tape they will refer to the 6.5 cc result that he achieved when he completed his own experiment. Again, referring to the very experiment that he's not allowed to refer to, given your instructions yesterday. Number four, there's still a ton of extraneous references on this tape which has absolutely nothing to do with the impeachment. Again, contrary to your specific instruction yesterday. Number five, you still have Mr. Goldberg on there as an unsworn witness, and what makes it much worse and more problematic is he's paraphrasing the grand jury and preliminary hearing testimony, but not quoting it accurately. In fact, he's misstating it at least twice, and I can point those out as well, and you'll see when he mentions it here, if you look at your transcript, the disparity will be quite obvious. And finally, there's two critical things missing from the tape. One is there's no explanation as to when he realized that his testimony at the preliminary hearing and grand jury were wrong. Thus, as a result of the way the tape is currently edited, the jurors will be free to speculate that it was right after he got off the witness stand, for instance, at the preliminary hearing in July of 1994, that he realized he was wrong, when in fact, even if you give his false statement about learning from a friend of a friend of a friend who was watching the trial on television, given that statement, he didn't realize he was wrong until after the trial began, and he knew what the defendant's theory of the case was, and he had heard or felt that perhaps the testimony he gave would screw the prosecution or hurt the prosecution. It's only then that he began to reassess what he had done. The way it exists right now is a suggestion that it could have happened the day after he testified. So that key element is missing. And finally, there's another segment on the tape where Mr. Goldberg asks him a question, and he mouths the words, "I don't remember," without actually uttering the words. I don't know if you recall that when you saw the tape yesterday. And to me, Your Honor, and to other people I've discussed it with, there's a suggestion that during this, prepping session that occurred between Mr. Goldberg and the witness before the tape actually started running, that certain things were scripted or prepared. And now Mr. Goldberg is asking him a question, and he's going, "I don't remember," although he doesn't actually say it, because he doesn't want to say it so it can be heard on the tape. He just mouths the words, and that too, seems to undermine his own credibility, and that's missing from this tape. But I'd just like you to look for those things when you see it, and I think the key thing is they simply didn't follow your instructions as to what had to be taken out.
Wasn't it your instruction to take out the experiment where he measures? We did.
Let's see the tape.
Photographer Teresa Ramirez, and this is going to be a videotaped interview, Thano, Thano, Paredes, Peratis, which is July 27th, 1995, and the time now is approximately 3:48 p.m. Again, this is just a backup tape for the videotape that we're going to be taping.
The tape reads 336.
Okay, tape reads on video 336.
Basically, what I wanted to do is just ask you about three statements that you made at the preliminary hearing, and we'll go through those one at a time. And the reason for videotaping, as I said before, is because there was a certain demonstration that you had wanted to show us, or thought it would be better if we had a videotape than if we just did it with an audio tape or some other way. And if you want to stop at any time you feel uncomfortable, for any reason, just let us know. And I know that you've just been through a traumatic incident in terms of your health condition. The first thing that I wanted to know about was the statement in the preliminary hearing to the effect of when you were asked how much blood did you withdraw from Mr. Simpson, where you said approximately 8 cc's.
Yeah, that was an estimation.
All right.
Because that's what we all think we draw at that time.
When you say we, you mean? And when you say that you think that you usually draw 8 cc's, that's based upon what?
Based upon what that container pulls out of the yarn.
Do you regularly measure how much you've drawn from a person after you've drawn the blood?
No.
Have you ever done it on any previous occasion prior to when Mr. Simpson came in?
Oh, I draw blood quite often, but not this way.
That you don't measure it?
No, we never measure any blood.
And when you said not to sort, what do you mean by that?
Well, usually I draw blood for people that are arrested on Friday.
Okay.
And that's a different tube and different method. And just draw it, and that's the officer, and that's it.
So was there something about this statement that I just mentioned to you where you were asked this question, how much blood did you withdraw from Mr. Simpson? You said approximately 8 cc's. And then you went on and you were asked, when you say approximately, did you not measure the amount? You said, well, it could have been 7.9 or it could have been 8.1. At some point, did you realize that that wasn't correct?
Not that day.
Okay.
I started measuring 1 cc, which would have been in the test tube, and I kept doing it until I got 8 cc's. When I saw how much 8 cc's was in the test tube, that was more than I drew. So I took another test tube and kept putting in water until it looked approximately as to what I had drawn. I measured that, and that was about 6.5 cc's. So I estimate that that's what I really had drawn. That's approximately 8 cc's right there. That was more than I drew.
And how did you know that?
Because it looks like it was more than I drew. So what I drew was approximately down to this point. There you go. Which should be 6.5 cc's.
So after you've done this, what conclusion did you come to?
I came to the conclusion I was wrong in the statement I made, that I didn't draw 8 cc's, that I drew about 6 to 6.5.
Is that an approximation?
That's still an approximation.
Yeah. There was another statement that I wanted to ask you about that also took place at the preliminary hearing. Let me just get hold of that. And that was the statement that said, I just looked at the syringe and it looked at about 8 cc's.
That was
Remember
a
that?
statement, which I should make. I looked at it, I should have said it looked like it was enough, which it was enough. 8 cc's, I was wrong in that 8 cc's altogether.
Can you show us what you did do in terms of looking at the syringe after the blood, or when the blood was being drawn? Mr. Simpson?
And here, okay, the blood was out. I pulled it out, I saw that, what it was, I squirted the blood into me. I just looked at the syringe.
Okay.
I didn't turn it over.
There is a part of the syringe that was
Well,
calibrated.
yeah, but I didn't, we just, unless you have a reason to look at those calibrations for dosage purposes, we just don't do it. I don't know how many nurses do. I've asked nurses, hey, do you know exactly how much blood you've drawn? No, about 8 cc's. So I want to make a bet and we'll check next time. Nobody wants to take the bet, take me on that bet.
So where did the figure at a 7.9, it could have been 7.9 or it could have been 8.1?
It was an approximation. Even what I did here, okay, 6.5, but it could be 6.4, it could be 6.6. You can't, this is not exact. None of this stuff is exact. If you have an order exactly, then you're very careful. We don't have any special forms of how much you draw. If somebody should request a certain amount of blood.
I'm so mad we can't see this while they're watching it. I'm so mad because I want to see him mouth. I don't know. I want to see if he actually does that.
Then I would be extremely careful to draw that much. So far, I never had a request like that.
Take blood with a syringe, a hypodermic syringe like the one that...
Most of the time we use them, I myself, most of the time I use the vacuum. But when I get someone as big as OJ, big arms, big muscles, I myself have found I can control it better when I use a syringe. Just go in, just I can see people, get my finger on that vein and go bang, not a problem. Other times, I can do a lot better just by using the other, you for example, I could do the other tourniquet, I could just go bing on you.
Now, when you say that you some usually use the vacutainer, what's that?
The vacutainer is, this is the vacutainer.
Oh, okay.
And what you do, you put a, I don't have one of those now, but you put a, it has a needle on this end too. You screw it in here. Then you put this in here, you inject into the, and then when you're in the vein, you push on this, and it just sucks the blood through.
Okay, that's based on the vacuum that's in the tube.
Yeah, on this now, I'm not what happened because Is there any error in there, we just suck it out, that's all. This is made for a different type of thing. They usually have a needle on the other end. You just check the needle.
How often do you use a syringe as opposed to a vacuum cleaner?
Oh, not very often. It's just when I get a big person. And put it like I make an evaluation of the arm, and that's you get in the habit to do right away. You look at the other, I look at him, I have no trouble. If he came in for anything, I'd immediately go for a vein right like that. I saw his eyes, and they had veins like that. Oh, these never hurt here. And I just run the bing bang at it. With anything on him, because those are nice big veins. I used to have those, and so I haven't ruined on this side. When you get something like OJ is, I'm thinking I've had other big people like that. And I usually just find it's a little easier, not only for me, but for the patient. You don't have to dig around, you just hit them, and that's it. And I haven't had any complaints of knowledge or anything.
Did you have any problems when you were drawing blood from the defendant?
No. I just, at this one certain point, as I was pulling, the needle hit the wall of the vein, and that's when it stopped. And so you could either turn your syringe and draw more. But at this point, it appeared like I had enough. So that was it, I just stopped it.
Is that when you looked at the syringe at that point where the needle hit the wall?
Well, my needle hit the wall, it's the only reason it stopped. It was the reason the blood would stop. And I figured, well, that's enough. In fact, every time I draw blood and I reach that point, it's just, well, you've got it, but there's no point in going any further. You can turn your needle and continue drawing, but there's a slightest, in my opinion, there's a slightest chance that you may damage the wall. I don't want to take that chance.
But when in relationship to the blood stopping, was it that you looked at the syringe? Oh, that was when it was?
Mm-hmm.
But you looked at the part that's opposite from...
Yeah, the calibration's on bottom.
Okay. All right.
Because again, that's not what we go by.
You're going by what?
No, we just go, it seems like you go by instinct. But I've never had a case where we never had enough blood.
You know, where they came back and said you didn't draw enough blood?
Yeah, I've never had a case where it says we need more. I don't know any case, and if there has been, I don't know any, in our department, I don't know anything about it.
Okay. I think that's about it, unless you have something else you want to speak. All right. Well, thanks a lot.
Well, you're sure welcome.
I think the videotape indicates that we obeyed the court's orders in terms of the excisions requested. There is no experiment performed by Mr. Paradas. The only reference to a demonstration he makes is an eyeball estimate of how much 8 cc's is, and that was more than he did, and that it looks more like it's 6.5. That's no more an experiment than having a witness testify, well, he stood about from here to there. Well, would you get down and show us how far he stood? Okay, you get down, well, no, it's a little closer. Okay, tell me when to stop moving. In the eyewitness identification cases. You call that an experiment? Or is that an experiment that requires the kind of foundation and cross-examination that Mr. Neufeld implies? I think not. This is a very simple, non-rocket science sort of thing. This is a man who's... Notice what I didn't say. This is a man who's looking at the test tube and eyeballing how much he thinks it is, for what it's worth. All of the tape goes to the aspect of how much blood he took and the approximation that he made of that, and the unreliability of any number attached to the amount that was contained in the test tube by virtue of the means by which he does it, and by virtue of the fact that he is not aiming for any particular amount. It's not a formal thing. The question he has to answer is, did I get enough? He got enough. The method he used by using the syringe, drawing the blood, it's not with a vacuum, so that means that he'll draw until he thinks he's got enough. I mean, that's really what it comes down to. He's not looking at the calibrated side of it. In this particular case, he hit a vein, and it stopped, and he figured, that's enough, and it's not worth trying to get more that I might injure Mr. Simpson, so I'll stop here. And that was all he was trying to do. And I think that the entirety of the tape that's what it makes clear. But to call an eyeball of an estimated amount of water in a test tube an experiment is really dignifying it way beyond the realm of reality there. And the aspect, I think, of the tape that the court wanted us to take out, we did. I thought we did. Is there more that the court would like us to excise?
I'll hear the comments from Mr. Neufeld.
Right, very specifically, the problem is not simply doing any kind of demonstration on the tape. He is describing orally verbally a demonstration that he conducted sometime in February of 1995. And that's what he's explaining. Even when he's not taking the syringe out now and doing the 1cc withdrawals, he is verbally explaining it to the camera. And that experiment itself does not substantially replicate what happened with Mr. Simpson back on June 13th of 1994. So both, I thought your ruling was very clear that no reference to either experiment could be included in this tape, and it's still there. There's even a reference to a demo I'm about to show you on this point. There's the reference to the 6.5 result of the experiment. And he's only holding this up after he completes the experiment. It's not just a description of what he remembers seeing. Now it would be 13 months earlier. All right, back in June, from June of 1994 to July 27th, 1995. It's not just that. And finally, Your Honor, one of the interesting things is what Mr. Goldberg does is he dissects the Q's and A's from the preliminary hearing. In the preliminary hearing, when he's asked, when you say approximately, the answer is I withdrew approximately 8 cc's. And the question then is, when you say approximately, you did not measure the amount? Answer. Well, it could have been 7.9 or it could have been 8.1. I just looked at the syringe and it looked at about 8 cc's. When Mr. Goldberg is asking him the Q&A on the tape, he doesn't include the I just looked at the syringe and it looked at about 8 cc's in conjunction with, well, it could have been 7.9 or it could have been 8.1. In fact, what he's saying is, when he says it could have been 7.9 or 8.1, I knew this because I looked at the syringe and it was about 8 cc's. By separating those statements, which is not the way it is in the preliminary hearing, it distorts the answer of the witness, where the witness is quite plainly, unequivocally, explaining under oath at a preliminary hearing that the reason he knows it's between 7.9 and 8.1 is because he looked at the syringe and it looked at about 8 cc's. And by separating that, you really paint a very distorted picture for the jury. And then, Your Honor, as I said before, it's missing those two very, very important elements, most important of which, of course, is when it first dawned on him that all of his testimony was wrong. That is a critical fact for the jury to assess.
But I thought that we agreed that all of that, your objection yesterday was that there was a lot of extraneous material in there, including the telephone calls from friends of friends of friends who told him that he had done all these silly things and the motivations for him having done this. I thought we agreed that that was extraneous hearsay.
No, what I said about the motivation, Your Honor, is that he lied about that. That what he told Mr. Blazer and what he told Joel and Demetrius when we were in his infirmary on April 11th is that he was personally watching the trial on television, using the same television that he showed us in the infirmary that day, which was glued to the channel that was covering the trial while we were actually there in the infirmary, that he'd watched Mr. Cochran give his opening statement, and it was when Mr. Cochran gave his opening statement that he realized, oh my goodness, my testimony at these hearings may have screwed the prosecution, and I ought to reconsider.
The fact that Mr. Parada says something on the tape that you feel you can rebut, that's for another decision. This is not the decision I had to make now.
No, but in terms of impeaching him, they want to impeach his earlier statement. The jury can't have half a glass on this. They are actually misrepresenting then the reality of this witness's statement by simply suggesting or allowing the jury to speculate. And that's the more dangerous thing here, Your Honor, that the jury could speculate that it was immediately after his preliminary hearing, more than a year ago, that it dawned on him that he had made this mistake, and so he went back and rethought about it. When we know, even if we take him at his word, that at best, it's sometime in February of 1995 after this trial has already begun. And there's a big difference between somebody innocently coming to the conclusion that he made a mistake and that his testimony was wrong a few days after he gave it, as opposed to here what he's saying is it came to me for the first time when he has in fact a motive to lie, if you will, only after Mr. Simpson's defense has been articulated to the jury on television. There's a huge difference between those two. So they'd have to include that.
You think they have to include?
I'm asking that portion be included, and when then need be, we will rebut it on serve rebuttal. I'm also asking that all the other portions of the tape, though, which are extraneous, be redacted or deleted from an edited version. But you can't really misrepresent or allow them to speculate as to when this dawned upon him, when it's very, very clear that no matter what the source of the dawning was, the timing is not in dispute. And the timing is not until after Mr. Cochran gave his opening statement.
All right, Mr. Martinez, I'd like to see, can you roll me up the point where Mr. Parada says that he was wrong, it was probably 6 to 6.5, and he shows the tube. That's about the second. There's 4 series of answers that he gives with regards to this issue. And while we're waiting for that, Mrs. Robertson, did you get in touch with the detectives?
The detectives were out until Your Honor, Mr. Matheson was packaging the items and bringing them over.
Perfect.
That was more than I drew.
And how did you know that?
Because it looks like it was more than I drew. So what I drew was approximately down to this point.
Okay, cool.
Which should be 6.5 cc's.
So,
Back before that.
Before that, Your
About 30 seconds before that. About 30 seconds before.
what conclusion did you come to?
I came to the conclusion I was wrong in the statement I made, that I didn't draw 8 cc's, that I drew about 6 to 6.5.
Is that an approximation?
That's still an approximation.
Yeah. There was another statement that I had to ask.
Can you roll back, I'm sorry, can you roll back about
Also-
30 seconds before that?
So, after you've done this, what conclusion did you come to?
I came to the
I need
conclusion
30 seconds before that.
So I estimate that that's what I really had drawn. That's approximately 8 cc's right there. That was more than I drew.
And how did you know that?
Because it looks like it was more than I drew. So what I drew was approximately down to this point.
Okay, cool.
Which should be 6.5 cc's.
So, after you've done this, what conclusion did you come to?
I came to the conclusion I was wrong in the statement I made, that I didn't draw 8 cc's, that I drew about 6 to 6.5.
Is that an approximation?
That's still an approximation.
Yeah. There was another statement that I had to ask you about that also took place at the preliminary hearing. Let me just get hold of that. And that was the statement that said, I just looked at the syringe and it looked at about 8 cc's.
That was
Do you
just
remember
a
that?
statement. I mean, I looked at it, I should have said it looked like it was enough, which it was enough. 8 cc's, I was wrong in that 8 cc's altogether.
Can you show us what you did do in terms of looking at the syringe after the blood? Or whatever it was?
All right, thank you, Mr. Martinez. Well, certainly not a presentation designed to make this easy. No, you have to admit that it does jump around. Yeah. All right, keeping in mind the limited use of this particular item, I'm going to allow its use. So the objection will be overruled.
So in its current form?
Current form.
Well, what about then a concern, Your Honor, which I haven't raised yet, pursuant to 356 of the Evidence Code, that I would like to then include certain segments in this?
Absolutely.
Well, the segments I would want them to include would be the segments where he took...
356 would allow you to do that if you want.
Okay.
I mean, this is kind of like a game. We were happy to have it in to begin with. Mr. Neufeld wants it. He complained about it yesterday. We took it out.
And we stopped and we went through all this trouble, and now I've had to watch it 3 times. You're right. But if there are items that aren't there that they want to put in under 356, as a matter of tactics, they're entitled to do that. I agree with you. This doesn't make sense, but let's proceed.
Well, we can put it back in. We have the original. We can put it back in so that we can play the whole thing for the jury. I mean, we do it this way. It's like the people are trying to hide something. And the unfairness of that is we were trying to show it to begin with and cut it out of their request. So I'm happy to put it back in. I don't think it's fair to create that impression.
Well, that won't be allowed to be argued. All right, let's have the jurors, please.
We play the tape and they're going to come back and play their excerpt, and whether they argue it or not, it's going to look like we were trying to hide something. People are being penalized for their objections that they're blind.
I didn't hear them withdraw the objection. They said under 356, do they have the opportunity to play portions they feel are favorable to them? The answer to that is yes.
But well, I agree, except that you understand the excision was made at their request.
I understand that.
Now they're playing an excerpt that they asked to be taken out, creating the impression in front of the jury that we're hiding something.
Do you want to withdraw the exhibit? That'll save us all the trouble.
And then penalize the people altogether because they changed their minds?
I'm not penalizing you, counsel. I'm letting you enter your evidence. Just step back into the jury room, please.
She was just slapped with $1,000 2 days ago. Is she really going to do this today? Is this what we're going to do today? He just sent the jury back
Jury's
in.
withdrawn. Have a seat, ladies and gentlemen.
Ooh.
Ms. Clark, for you to suggest that this court is penalizing you, I think borders on contumacious conduct on your part. That's the second time you've done that. You're warned. In no uncertain terms. Do you understand me?
I do. I meant nothing like that.
Say out the jury, please.
It was spectacular.
Ladies and gentlemen, please be seated. All right, let the record reflect that we've been rejoined by all the members of our jury panel. Sorry about that start and stop there. Ladies and gentlemen, the next item that will be presented to you will be People's Exhibit 615. It is a videotape of a statement. It is going to be allowed, I'm going to allow its viewing, the excerpts from this videotape for a limited purpose. It is presented to you for the limited purpose of evaluating the credibility of the witness that it involves. All right? Ms. Clark, you may present 615.
Well, I'm sorry, I understand they're calling a witness.
Well,
Hey.
when we get to the videotape.
Thank you. People call Mr. Rockwood.
Raise your right hand, please. You do solemnly swear that the testimony you may give in the cause something in the court should be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Please have a seat on the witness stand, so your first and last name is correct.
Stephen, S-T-E-P-H-E-N, Oppler, O-P-P-L-E-R.
All right, Mr. Rocker, would you pull the microphone closer, please?
Closer.
Thank you.
Mr. Opper, can you tell us what you do for a living?
I'm a senior investigator for the District Attorney's Office.
Okay, would you pull that mic a little closer so we can hear you?
Want me to repeat it? Do you need me
I
to
think
repeat
everybody
it?
heard that.
Okay.
All right. Sir, directing your attention to the date of July 27th, 1995, on that date, did you conduct an interview of a person by the name of Thano Paradas?
Yeah, actually, Deputy District Attorney Hank Goldberg, that I was with him, assisting him.
You were present?
Yes.
And was that interview videotaped in your presence, sir?
Yes, it was.
Now, do you know where did this take place, this videotape?
At his home.
Mr. Paradas' home?
Mr. Paredes' home.
And why was it done there?
It was my understanding that he had just had an operation concerning his heart. I don't know the specifics of it, but he had a heart operation.
So you were there at his home taping due to a medical condition of his?
Right.
Now, was was there any rehearsal prior to beginning the videotaping of that interview?
No. No, none.
In other words, as soon as you got there, the questioning began and the videotape started running? It is. When you began did you begin questioning at the same time you began videotaping?
Yes.
So the interview, would you characterize it as spontaneous?
Yes.
Yes, answer certain.
How would you characterize the interview, sir?
Spontaneous.
What a coincidence. Let me ask you something else, sir. With respect to this tape, did Mr. Paradas explain to you, over the course of the tape, something that caused him to re-examine his testimony given at the preliminary hearing in the grand jury?
Objection, Your Honor. It speaks for itself.
That objection's overruled. Sustained.
Can you repeat it?
Sustained.
Oh, I'm sorry.
Sir, were you present during a hearing just now that took place in the court?
For most of it.
And did you hear the defense request the excision or...
Sustained. Sustained. That's not appropriate.
Was Mr. Paradas asked any question by Mr. Goldberg concerning what prompted him to do, to reevaluate his testimony at the preliminary hearing?
Objection hearsay.
Sustained.
Question?
Sustained.
Do you recall the subject matter of Mr. Paradis's, of what prompted Mr. Paradis's review of his preliminary hearing
Objection,
testimony coming
hearsay.
up?
Sustained.
Sir, have you observed the videotape that's about to be shown to the jury?
Yes, I have.
Okay, and has that videotape been edited at the court's request?
Objection, Your Honor.
Sustained.
Does that videotape contain everything that was conducted, every part of the interview that was conducted on July 27th, 1995?
No.
Thank you. I'm going to show you a portion of the beginning of that tape and ask you to identify it, indicate whether or not that is the taping that you recall being conducted in your presence on July 27th, 1995 of Thano Paradis.
Okay. Photographer Teresa Ramirez, and this is going to be a videotaped interview. Thano, T-H-A-N-O, Paradis, P-E-R-A-T-I-S. It's July 27th, 1995, and the time now is approximately 3:48 p.m. Again, this is just a backup tape for the videotape that we're going to be taping.
The tape reads 336.
Okay, tape reads on the video 336.
Basically, what I wanted to do is
You've seen that, Mr. Opler?
Yes, I have.
Do you recognize the voice that introduces the video?
Yes, that's mine.
And the person that is shown on the videotape, who is that?
That's Mr. Paradis.
And do you know what his role is in this case?
As I understand it, he took the blood. He withdrew the blood from Mr. Simpson for testing purposes.
And the other voice that you heard just before the tape was stopped. Do you recognize that voice?
Deputy District Attorney Hank Goldberg.
Was that the videotaped interview that was conducted in your presence on July 27th, 1995 of Thano Paradis?
Yes.
statements that you made at the preliminary hearing, and we'll go through those one at a time. And the reason for the videotaping, as I said before, is because there was a certain demonstration that you had, I don't know, show us, we thought it would be better if we had a videotape than if we just did it with an audio tape or something. And if you want to stop at any time, you feel uncomfortable, for any reason, just let us know. And I know that you've just been through a traumatic incident in terms of your health condition. The first thing that I wanted to know about was the statement in the preliminary hearing to the effect of when you were asked how much blood did you withdraw from Mr. Simpson, where you said approximately 8 cc's.
Yeah, that was an estimation, because that's what we all think we draw at that time.
When you say we, you mean? And when you say that you think that you usually draw 8 cc's, that's based upon what?
Based upon what the vat container tube pulls out of the yarn.
Do you regularly measure how much you've drawn from a person after you've drawn the blood?
No.
Have you ever done it on any previous occasion prior to when Mr. Simpson came in?
Oh, I draw blood quite often, but not this sort.
But you don't measure it?
No, we never measure any blood.
And when you said not the sort, what do you mean by that?
Well, usually I draw blood for people that are arrested for driving.
Okay.
And that's a different tube and different method. And just draw it, and that's give to the officer, and that's it.
So was there something about this statement that I just mentioned to you where you were asked this question, how much blood did you withdraw from Mr. Simpson? You said approximately 8 cc's. And then you went on and you were asked, when you say approximately, did you not measure the amount? You said, well, it could have been 7.9 or it could have been 8.1. At some point, did you realize that that wasn't correct?
Not that day. I started measuring 1 cc and squirted in the test tube, and I kept doing it until I got 8 cc's. When I saw how much 8 cc's...
Excuse me, Mr. Opler. After Mr. Parada said not that day, did he go on to give some further explanation of that topic?
Objection, Your Honor.
Yes, he did.
And was that previously on the tape?
Yes, it was.
That was more than I drew. So I took another test tube and kept putting in water until it looked approximately as to what I had drawn. I measured that, and that was about 6.5 cc's. So I estimated that's what I really had drawn. That's approximately 8 cc's right there. That was more than I drew.
And how do you know that?
Because it looks like it was more than I drew. So what I drew was approximately down to this point. There you go. Which should be 6.5 cc's.
So, after you've done this, what conclusion did you come to?
I came to the conclusion that I was wrong in the statement I made, that I didn't draw 8 cc's, that I drew about 6 to 6.5.
Is that an approximation?
That's still an approximation.
Yeah. There was another statement that I wanted to ask you about that also took place at the preliminary hearing. Let me just get hold of that. And that was the statement that said, I just looked at the syringe and it looked at about 8 cc's.
That was
Remember
that statement, which I agreed with me. I looked at it, I should say, it looked like it was enough, which it was enough. 8 cc's, I was wrong in that 8 cc's altogether.
Can you show us what you did do in terms of looking at the syringe after the blood, or when the blood was being drugged? Mr. Simpson.
Syringe here. Okay, the blood squirted out. I pulled it out. I saw that what it was, I squirted the blood into the I just looked at the syringe.
Okay.
I didn't turn it over.
There is a part of the syringe that was calibrated.
Yeah, I didn't, we just, unless you have a reason to look at those calibrations for dosage purposes, well, you just don't do it. I don't know how many nurses do. I've asked nurses, hey, do you know exactly how much blood you've drawn? No. About 8 cc's. Now, you want to make a bet and we'll check next time? Nobody wants to take the bet, take me on that bet.
So where did this, the figure 7.9, it could have been 7.9 or it could have been 8.1 come from?
It was an approximation. Even what I did here, okay, 6.5, but it could be 6.4, it could be 6.6. You can't, this is not exact. None of this stuff is exact. If you have an order exactly, then you're very careful. We don't have any special orders of how much you draw. If somebody should request a certain amount of blood, then I would be extremely careful to draw that much. So far, I never had a request like that.
Take blood with a syringe, a hypodermic syringe like that?
Most of the time we use them, I myself, most of the time I use that one. But when I get someone...
It appears the monitor is flickering in the jury box. All the monitors are flickering.
All right, Mr. Mormon, apparently everything but the big screen is jumping.
I think it has to do with the quality of the content. The digitized video seems to be more sensitive than the direct video.
All right, juror number 1, juror number 7, and 8, is that watchable for you? All right.
Number 7 can't
any
see
of
it,
you,
sir. Dumbass.
Those of you who are watching the small monitor in the front want to take seats further in the jury box so you can see the big screen, or do you want to stay where you are? All right, let's proceed. Thank you, Ms. Clark.
I myself, I can control it better when I use a syringe. You just go in and just make it see people. You might.
Excuse me, it jumped a little bit. We're going to rewind so we can begin. If it skipped some.
Other times, I can do a lot better. When I use a syringe.
Go ahead.
You just go in and just make it see people. Keep my finger on that vein and go back without a problem. Other times, I can do a lot better just by using the other. You, for example, I could without a tourniquet, I could just go bing on you.
Yeah, that's something there. Now, when you say that you usually use the vacutainer, what's that?
The vacutainer is, this is the vacutainer.
Oh, okay.
And what you do, you put a, I don't have one of those now, but you put a, it has a needle on this end too. You screw it in here. Then you put this in here, and you inject into the, and then when you're in the vein, you push on this, and it just sucks the blood through.
Okay, that's based on the vacuum that's in the tube.
See, on this, no, nothing would happen because if there were any air in there, it would just suck it out, that's all. But this is made for a different type of thing. They usually have a needle on the other end. You just inject the needle.
How often do you use a syringe as opposed to a vacuum cleaner?
Oh, not very often. It's just when I get a big person.
Popcorn is called for right now.
And like I make an evaluation, you know, and that's you get in the habit to do it right away. You look at the other.
Exciting blood draw.
Have no trouble. If you came in for anything, I'd immediately go for a vein right like that. I saw his eyes and they had veins like that. Oh, these never hurt here. And I just go out there, bing bang, and I put anything on him because those are nice big veins. I used to have those until I had ruined on this side. When you get some of that with OJ is on the big, I've had other big people like that. And I usually just find it's a little easier, not only for me, but for the patient. You don't have to dig around, you hit them and that's it. And I haven't had any complaints of an ouch or anything.
Did you have any problems when you were drawing blood from the defendant?
I just, at this one certain point, as I was pulling, the bevel of the needle hit the wall vein, and that's when it stopped. And so you turn your syringe and draw more. But at this point, it appeared like I had enough. So that was it. I just stopped it.
Is that when you looked at the syringe at that point where the needle hit the wall?
Well, I might have needle hit the wall. It's the only reason it stopped. It was the reason the blood would stop. And I figured, well, that's enough. In fact, every time I draw blood and I reach that point, it's just, well, you've got it, but there's no point in going any further. You can turn your needle and continue drawing, but there's a slightest, in my opinion, there's a slightest chance that you may damage the wall. I don't want to take that chance.
But when in relationship to the blood stopping, was it that you looked at the syringe?
Immediately.
Oh, that was when it was? But you looked at the part that's opposite from...
Yeah, calibration's wrong bottom.
Okay. All right.
Because again, that's not what we go by.
You're going by what?
No, we just go, it seems like you go by instinct. But I've never had a case where we never had enough blood.
This is pointless and long.
Yeah, where they came back and said you didn't draw enough blood.
No, I've never had a case where we need more. I don't know any case, and if there has been, I don't know any, in our department, I don't know anything about it.
Okay. Yeah, that's about it, unless you give us one to speak.
Mr. Oppler, the entire tape, that is not the edited version that you see here, but the entire tape was given over to the defense, correct?
Yes, as far as I know.
And when Mr. Paradas referred to I could just go bing on you, I don't need a tourniquet, who was he referring to?
He was referring to me.
Were you wearing short sleeves that day?
Yes.
I have one request of the court, if I can make it at sidebar.
All right, thank you, counsel. Ladies and gentlemen, if you recollect, I indicated to you that the tape that you just saw was to be used by you for the limited purpose of evaluating the credibility of Mr. Paradas, whose testimony you saw previously. Also, there was some editing that was apparent in the videotape, and you should know that that editing was done at the court's order. All right, Ms. Clark, you have anything further for Mr. Oppler?
No, thanks.
It was slightly important, but not really. It was sort of pointless, Angela. Tina, you're right. So, the guy who drew blood from O.J. Simpson's arm, in the preliminary hearings, said that he drew 8 cc's. But when they measured the tube later, there was like, I don't know, 6.5, 7 cc's. So, Tina said she's drawn a lot of blood, and you never know how many cc's you draw. I would believe that. I would, because, you know, I measure things with water, and one pool on it, I don't know, it's just, so the prosecution is saying, you know, there was just a guesstimate, blah, blah, blah. But the defense is saying, no, there's blood missing. OJ's blood is missing. And Mark Furman planted it on the scene, in the gloves, on the socks, in the Bronco. Mark Furman planted the blood, and that's why there's some missing. So now they're trying to clean up their mess, saying that they got this guy back on the stand through this tape, and he did an experiment on how he draws blood, and he pulled like 6.5 cc's or whatever, and that's what he normally, but it's too late. The jury, I don't know. I mean, you would think they would know that, you know, 8 cc's is a guesstimate, but we all know how it ends. So it's pointless. It's useless.
All right. Any questions for Mr. Oppler?
I do.
All right.
Thank you. Good afternoon, ladies and gentlemen. Mr. Oppler, is it Oppler?
Yes.
Okay, thank you. Mr. Oppler, how many years have you worked as the district attorney?
November will be 7.
7 years?
Yes.
Okay. As an investigator?
Yes.
Did you prepare any notes or reports in connection with this taping that occurred on July 27th of this summer?
Yes, there was a small report.
Did you have a copy of it with you?
I have it in my file upstairs.
May we have a sidebar, Your Honor?
All right, ladies and gentlemen, we're going to take a brief recess just to secure a copy of that report. It should only take about 5 or 10 minutes. Let me ask you to step back into the room. Mr. Oppler, go upstairs, get your report.
Thank you.
All right.
Sanctions! Tina.
Possible, I mean, the jurors may. Can I have a 3-minute rest break? 2 minutes.
2 minutes.
Yeah, that's right.
Can I copy?
Oh, is it okay to see it?
Well, after you handed it over, I assumed you knew what it was.
Oh, save time, Judge.
Can you just have a 4 minute break?
Well, we're going to take a break at 3. Can it wait till 3?
Sure.
All right. I mean, I'd like to finish, if at all possible.
The time on the video says 1:23, 39, 40. No, that's just how long into the tape we are. Never mind. I was wondering if that's how close to 3 it was. I was wrong.
I will edit the brief portions I intend to use on our cert rebuttal. I have to take our original back to do that. So I just want the witness to be on recall for the 5 minutes or whatever it'll take to recall on either Friday morning when we begin our cert rebuttal case or Monday. That's the only way I can proceed because I don't have an edited version of those segments.
I assume the prosecution will finish either Friday or Monday.
Right, I'm saying that's...
Yeah. All right, no, Mr. Oppler will be available.
Thank you.
All right. So ordered.
If we can resolve the Dutton issue tomorrow, we can rest tomorrow. I don't want to go to Friday. I'd like to rest tomorrow.
Was that what she said?
She indicated that people want to rest tomorrow after Diedrich and whatever is all.
I would think you can stop the Dutton issue very, very, very easily. I would step out and call the dean over. If they promise to rest, I'll ask them to come down here tomorrow.
But we can't promise there's cross-examinations, Mr. Scheck. I mean, I don't know, we've got 2 witnesses.
Well,
I don't think-
let's-
yes.
Thank you, ladies and gentlemen. Let the record reflect we've been rejoined by all the members of our jury panel. We found the report. Mr. Neufeld.
Thank sorry about that. Mr. Oppler, you said you've been with the district attorney's office as an investigator about 7 years?
Yes.
And this investigation you went out on July 27th of 1995, that was at the request of Deputy District Attorney Hank Goldberg?
Through my lieutenant, yes.
And had you, did you actually set up the appointment with Mr. Paradas?
No, I didn't.
When were you first notified that you were going to be going to Mr. Paradis's on July 27th?
Earlier in that day.
And have you been working on this case, sir,
Yes.
since the beginning?
Since October of last year.
All right. So you knew when you went out to Mr. Paradis's house this past July 27th that Mr. Paradis had given sworn testimony to a grand jury in this case. Is that correct?
I was informed of that.
Okay. And you knew when you went out on July 27th that Mr. Paradis had also given sworn testimony as a witness called by the prosecutor, Marcia Clark, at a preliminary hearing on July 7th of 1994. Did you know that too?
I understood that, yes.
Okay. And you were told when you went out on July 27th to Mr. Paradis's home of this year, 1995, that the purpose of this taping was to obtain statements which would impeach or contradict the sworn testimony that Mr. Paradis gave approximately 1 year ago. You knew that too, didn't you?
I don't know so much in those terms. What I was informed of was that he conducted a demonstration to himself.
Sir, I'm asking you whether or not you were told when you went out there on July 27th that the purpose of this taped interview was to secure a statement from Mr. Paradis which would be used to impeach his own sworn testimony that he gave on July 7th of 1994 and June 22nd of 1994. Were you told that? I'm sorry, not were you told that, did you know that?
Objection, argumentative, hearsay.
Sustained.
Now, did you know when you went out there on July 27th of 1994 that this taping was being conducted because a determination had been made that Mr. Paradis was unavailable to come into court and be sworn in as a witness because of his poor health?
Yes.
And you knew when you went out there on July 27th to conduct this taped examination, or interview, I should say, of Mr. Paradis, that he wasn't going to be sworn in before he gave the statement to you. Isn't that correct?
I was never told he was going to be sworn in. No.
Okay. And you knew that because this interview was going to be conducted at Mr. Paradis's home, he was never going to be subjected to cross-examination, as he had been at the preliminary hearing when he was called by Marcia Clark.
Objection, irrelevant, calls for speculation.
Sustained.
Well, Mr. Oppler, did you make any effort on July 27th before you went out to Mr. Paradis's home to notify the defense so they could have a lawyer present for this interview?
No.
Objection,
Overruled. Overruled.
Did you, sir, make any effort on July 27th to notify the defense so at least a defense investigator could be present?
No.
Objection, irrelevant.
Overruled.
And finally, sir, did you make any effort on July 27th to ensure that some independent person who was neither associated with the prosecution nor the defense could be present for this taped examination at Mr. Paradis's home?
Sustained. That's irrelevant.
What time did you arrive at Mr. Paradis's that day?
Approximately 3:15, 3:20.
And when you arrived at Mr. Paradis's home, did he let you in?
Yes.
And was he alone or with someone?
He was alone.
And where did he take you when he let you in, sir?
Originally, we went into the room adjacent to the entry, which I think was the living room, and we ended up upstairs in a room that was more like a den.
And how long did you stay in the living room before you went upstairs to the den?
Just a few minutes.
And who made the decision to go upstairs instead of doing it downstairs?
I believe it was Mr. Paradis said it would be more comfortable up there.
And sir, you said you arrived sometime between 3:15 and 3:20?
Approximately.
Now, according to the tape, the tape itself shows, I believe, one time, but you hear a voice over on the tape saying it's a different time. Is that correct?
That's correct. I was when I initially put the heading on the tape, I stated 3:48 when in fact my watch was 3:38. The photographer said the tape on the video was 3:36. I checked my watch; it was 3:38, not 48. I was in error when I first said that. And on my backup audio cassette, which I was making, I believe I corrected that at the end of it.
So if you arrived between 3:15 and 3:20, and the taping began at approximately 3:38, that would mean that there was about 20 minutes while you were there at Mr. Paradis' home before you started rolling the tape. Isn't that correct?
When I say 3:15, 3:20, because we have radio and radio codes, that's when I called into the office. Then we walked to the house. We got there a minute or so later, and then and at that point we were downstairs, then went upstairs.
So, Mr. Oppel, am I correct in saying that it's approximately 15 minutes that you were there at Mr. Paradis' house before the tape began rolling?
Yes.
And it's your testimony that during that 15 minutes, other than saying, let's move upstairs so we'll be more comfortable, there was absolutely no discussion between Deputy District Attorney Hank Goldberg and Mr. Paradis.
There was no discussion regarding what the content of the tape would be.
You remember that specifically, sir?
I remember we weren't going to discuss that.
Now, during those 15 minutes before the tape started rolling, did Mr. Goldberg assure Mr. Paradis that he could say whatever he wanted to say because he wouldn't be sworn?
Sustained.
During the 15 minutes, by the way, you noticed that Mr. Paradis was holding a syringe at one point on the tape and holding a vacutainer. Did you and Mr. Goldberg bring that equipment with you to his house?
No.
He had it there already?
Yes.
He had it sitting out when you arrived?
I don't recall where it was when we arrived.
Now, sir, you said that that on direct examination that he was not rehearsed while you were there on July 27th. Is that correct?
Yes.
But during the course of this interview at Mr. Paradis' house, didn't Mr. Goldberg refer to other conversations and discussions that he had with Mr. Paradis?
I don't recall. I'd have to see that tape again, that part of it where it said that. I don't recall every piece of that tape if he had that discussion.
To the best of your recollection, Mr. Goldberg never said during the course of the tape or bring up the fact that he had any prior discussions with Mr. Paradis before just showing up on July 27th out of the blue?
Bobby, I need to make sure you're still here. Are you still
I
here,
didn't say
Bobby?
he never said it. I said I don't recall if he said that.
And you learned, sir, during the course of this examination, or your participation in this outing on July 27th, that Mr. Paradis had been an employee of the Los Angeles Police Department for some 30 or 40 years, did you not?
I didn't know the exact number of years. I knew it was many years.
And sir, you also learned during this outing on July 27th that the first time Mr. Paradis ever believed that his testimony, his sworn testimony, was false, was after this trial actually began. Did you learn that on July 27th?
Yes.
And did you learn,
Overruled, slate.
and did you learn on July 27th, one moment, that it was only after he learned that it was the defense theory through opening statements
Calling for a conclusion on the part of this witness. This is somebody else. Sustained.
during this interview with Mr. Paradis at his home, did he show you the syringe, or an exact replica of the syringe that was actually used to draw blood out of Mr. Simpson's on July 13th, 1994? I'm sorry, June 13th, 1994?
Objection to foundation.
Overruled.
He showed us a syringe that said it was like the one that he used. I don't know if the exact replica was it, but
And in the syringe that he showed you, that he said was like the one that he used, didn't it have calibrations on the syringe itself with numbers so that anyone who looked at the syringe and saw liquid in it would know how much was there?
the syringe had calibrations on it.
And when we say calibrations, it had numbers indicating whether it was 1 cc, 2 cc's, 6 cc's, or 8 cc's, didn't it?
I didn't see it up close whether it said cc's or milliliters or what was the exact markings, but it was calibrated.
And it was calibrated with numbers
Right.
indicating quantities.
Right.
And it was calibrated with lines next to the numbers, so you could see where the liquid was at a certain point, couldn't you?
Correct.
And it was at that point that Mr. Piranhas, during this interview, told you and the Deputy District Attorney, Hank Goldberg,
Sustained.
there was a time when we looked at the videotape where the image was jiggling a little bit. Have you seen a version of that tape where the image doesn't jiggle at all?
Yes.
And I noticed that when Mr. Paranis is giving an explanation of what he did when he looked at the syringe, when trying to explain his preliminary hearing testimony in which he's...
Sustained. Phrase the question.
Do you remember the portion in the tape where Mr. Goldberg brings out the fact that Mr. Paranis had testified under oath that the amount in the syringe, the amount drawn could have been 7.9 or it could have been 8.1. I just looked at the syringe and it looked at about 8 cc's, unquote. Do you remember when Mr. Goldberg brought that point up to Mr. Paranis?
Yes.
Overruled.
And do you remember when Mr. Paranis showed you the syringe with the calibrations, the numbers and lines on it to indicate how much liquid would be in a syringe? Do you recall that?
Yes.
And do you recall that on this tape, he says, or I'm sorry, he then turns the syringe over.
Sir, stop.
So you can't see the numbers in calibration.
While I was driving, I heard, I think, Cochran, say, I don't want to be the one, something about calling another witness, and every time they call another witness, they get cold stares from the jury. The jury is done. The jury's pissed. The jury does not want this to go on anymore. And he's asking these stupid questions right now, and it's pissing me off. And I can go take a nap and eat a cookie if I want to.
You only see a portion of the syringe that has no numbers on it. Do you recall that?
Yes.
Sir, is it your testimony that neither you, no, I'm sorry, that Deputy District Attorney Mr. Goldberg had no discussion at all with Mr. Paranis about how he held the syringe 12 months ago on June 13th before he uttered that description during that videotape session last month?
Are you speaking before we filmed the tape, or I'm not sure I understand the question.
Before you filmed the tape that day, on that day. That's the time frame I'm talking about.
Right, before the filming of the tape is what you're saying.
Yes. Do you understand the question? I can rephrase it if you'd like.
I'd like you to, please.
Sure. Prior to Mr. Paranis turning that syringe over, so he said that the numbers and calibrations couldn't be seen when he withdrew the syringe. What I'm asking is, did that subject come up at any time at all in the discussion between Deputy District Attorney Hank Goldberg and Mr. Paranis before he gave that statement on the videotape that day?
No.
There was no demonstration by Mr. Paranis off camera before the taping started of how he may have held the syringe?
Not in my presence.
Was there any mention in your presence of a concern that he had testified under oath that I just looked at the syringe and it looked at about 8 cc's? Was there any discussion at all that that would be a problem for the prosecution?
No.
Sir, at any point at all during that day, was there any substantive discussion held about this case when the tape was not running?
No.
So your testimony that the tape ran continuously and there was no time when the tape was turned off and discussion about the substantive facts of this case occurred?
No, the only downtime when we got there was when the photographer was setting up her equipment.
Mr. Opler, isn't it a fact that according to the clock on the tape, on the original tape that you provided to the defense in this case, that the tape stops at 3:59 p.m. and resumes at 4:13 p.m. with approximately 14 minutes of downtime in between? Isn't that correct, sir?
Objection. Objection, Your Honor. Seems facts not in evidence.
Overruled.
Hearsay, irrelevant.
Overruled.
352, misleading.
Can you repeat that, please?
Isn't it a fact that when you went to Mr. Paranis' home to make this tape and to interview Mr. Paranis, that the tape was turned off at 3:59 and resumed at 4:13, some 14 minutes later?
I don't recall that specifically. I think that there might have been a time that the photographer was checking and making sure that it was recording correctly.
Well, sir, you testified that the time the tape began was approximately 3:36. Is that right?
Approximately.
Well, if the tape was turned off at 3:59, that would be 23 minutes after the tape started. Is that correct, sir?
Yes.
And if the tape was turned off at 3:59 and resumed at 4:13, some 14 minutes later, that certainly wouldn't be for the purpose of making sure the tape was working, would it, sir?
Probably not. I do recall her doing that. That may have been at the end just to make sure that the tape recorded before we left. So at that time, possibly that wasn't the reason
Sir, other than the fact that the tape was working, is it your testimony that there was no that there was no break in this tape of some 14 minutes before you resumed this witness describing his position regarding his handling of the evidence in this case? Is that your testimony?
I don't recall the reason that the tape stopped. Other than being on tape, there was nothing substantive spoken about.
Sir, are you changing your testimony when you said a moment ago? One moment. Your Honor, I just need to get a little portion of the tape queued up. Sir, while he's queuing that up, let me ask you one other question. Was there ever a time during this interview on tape where Mr. Paradas, instead of actually speaking, mouthed words, "I don't remember"?
I do recall him mouthing words. I don't remember if it was I don't remember.
Well, if it had been him mouthing words, "I don't remember," but not saying that, would that be in response to his inability to remember that portion of the script that was given to him?
No.
Sustained. Answer stricken. Question and answer stricken.
Well, sir, if in fact he mouthed the words, "I don't remember," are you sure that that would not be in response to something that had been discussed with him before the tape ran?
I'm positive. We didn't discuss anything concerning what we would be filming.
Are you as positive about the fact that you didn't discuss the substance of his testimony before the substance of his interview, of his unsworn interview, before the tape began running, as you are that there was no 14-minute break in the tape in which, after that break ended, you resumed the substantive discussion of the facts of this case?
Sustained.
Sorry. Sorry, Your Honor, we're just queuing it up, and it's my fault.
We'll take a recess at this point. I'm going to take our recess at this point. All right, ladies and gentlemen, we're going to take our mid-afternoon recess. Remember, all my admonitions to you. Mr. Opler, you may step down. You're to come back in 15 minutes, all right? 15. All right, let's have the jury, please. All right, thank you, ladies and gentlemen. Please be seated. All right, let the record reflect that we've been rejoined by all the members of our jury panel. Mr. Stephen Opler is on the witness stand undergoing cross-examination by Mr. Neufeld. Mr. Neufeld, you may conclude your cross-examination.
Thank you very much. Mr. Opler, do you consider yourself objective and fair?
Yes.
Or will.
When we just took this 15-minute recess, sir, did I...
35.
Okay. When we just took this 35-minute recess, sir, did I approach you when you came down to the stand and ask if I could speak to you for a few minutes alone?
Yes.
And did you at that time refuse to speak with me alone and instead state that you would only speak with me if the prosecutor, Ms. Clark, was present?
I stated I would be more comfortable.
Well, then I asked you after that, sir, if you would speak with me alone, notwithstanding the fact that you would be more comfortable to have Ms. Clark there, did you then say, I will not speak with you alone unless Ms. Clark is present?
After about 4 or 5 times, when you kept saying, are you saying, will you not speak to me? I said, I would prefer Ms. Clark be there.
And after you kept saying that 3 or 4 times, sir, did you then say by that preference that you would be unwilling to sort of just walk over to the other side of the room with me alone and speak with me?
Yes.
Isn't that what happened?
That's what happened.
And, sir, is that because you felt as a witness it's important to have both sides present when I interview you?
I don't know specifically what I thought. I was in the middle of you questioning me, and to do it off the stand, I did not feel comfortable.
Well, let me ask you this. Did you think that it would be the better practice, sir, that when you went out to Mr. Paradis to have someone from the other side present as well?
Objection has been answered.
Sustained.
Now, even after Ms. Clark came over, and the 3 of us stood over in the well there during the break, you recall me asking you a question off the record, over there in front of Ms. Clark, whether or not after all the taping was done for the day, whether Mr. Paradis said anything to you at all about the substance of this case. Do you recall me asking you that?
Something to that effect.
And do you recall, sir, that when I asked you that, even in front of Prosecutor Ms. Clark, that you said you wouldn't answer me there? Recall that, sir?
That was at the point where I just said that I would feel more comfortable. I'm sorry, excuse me. I did not feel comfortable in what we were doing, and I said I would answer anything under oath.
And did you say, sir, that you wouldn't even answer my simple question over there with Ms. Clark present?
Sustained.
Isn't it a fact, sir, that you then refused to talk to me at all about the substance of this case, even with Ms. Clark present during the recess?
Yeah, at that point, I really wasn't feeling comfortable. You kept repeating the same thing, and then I decided that it didn't feel appropriate to me.
Okay. But then after I walked away, you did have a conversation, of course, with Ms. Clark and with Mr. Darden, didn't you?
I spoke to them.
Now, you consider yourself fair and objective. Is that true, sir?
Absolutely.
Oh, I think we need to mark this segment as an exhibit, Your Honor.
How do you propose to capture it? You're going to provide us with a separate video of this segment?
Yes.
Mrs. Robertson, defense 1376.
You notice it's 3:59 on the clock?
Yes.
Well, you're welcome.
Can you back?
I'm going to conclude my earlier date.
Okay.
I'm going to inject this 12 cc's into this syringe. I'll pull out some here.
Is that Mr. Goldberg's voice in the background, sir?
Yeah, I believe it was.
This syringe now has 12 cc's of water in it.
Thank you. You can stop. Sir, did you notice the clock?
Yes.
Did you notice that the tape stopped at 3:29 p.m.? 3:50. Sorry. 3:59 p.m. Did you notice that, sir?
Yes.
And did you notice that the tape resumed at 4:13 p.m.?
Yes.
So there was 14 minutes when the tape was not playing. Is that correct, sir?
Yes.
Now, is it your testimony that just all of a sudden, after 14 minutes of no taping, that the tape was simply turned on and Mr. Paradis is sitting there with the syringe and the vial?
Sustained.
Didn't you testify, sir, earlier on cross-examination that there was no substantive discharge at all unless the tape was running?
I believe I said that. After seeing that and recalling, after we stopped the tape, I don't recall specifically if it was Mr. Paradis saying he wanted to show us something or if it was Mr. Goldberg saying that there was something he forgot to mention, but we went back on the tape. Teresa, the photographer, had been packing up and then reset it up and we went back on the tape.
Is it your testimony, sir, that during the 14 minutes after the first portion of the tape ended, that all that was said was, oh, there was something I forgot to bring up, or Mr. Goldberg said, oh, there was another question I wanted to ask you. Is that what you're now saying, sir?
To the best of my recollection, that's what happened.
And during the break, sir, did you see this portion of the tape during this 35-minute recess we just took?
No.
Sir, were you standing in this courtroom when Mr. Harris played the tape with you standing here and Ms. Clark standing right here?
Ms. Clark said she wanted to see it. I was standing there, but I was not watching the monitor.
It's your testimony, sir, that you were standing here during the break and the tape was playing and the audio was playing, but you didn't watch it at all?
It was on.
Is that your testimony,
It was
sir?
on. I noticed it was on. I spoke to a lot of people during the break, and I think that might have even been the time that Ms. Martinez was in here. I was speaking to Mr. Darden, Ms. Clark. It was on. I recall Ms. Clark saying that she wanted to see it on that screen. I was not watching it at that point.
Mr. Opler, the last series of questions before we broke the recess dealt with your failure to acknowledge that there was a 14-minute gap between the first portion of the tap. Okay. You recall that this subject of the tape being turned off for several minutes, 14 minutes, and then being turned on again, was the
Sanctions.
last thing we were talking about before the break. Do you recall that?
Yes.
And it's your testimony now that when I finally, during that 35-minute recess, played the segment that you just saw now.
Asked
You
and
weren't watching,
answered
you weren't paying attention?
again and
Is that
again.
your testimony?
That's what I just said, yes.
Thank you. Nothing further.
That's what he said a couple times.
Mr. Opler, when you came down to court today, what did you expect to be doing?
To introduce...
Sorry, I couldn't hear the question, Your Honor.
You have it right there in front of you, don't you?
No, I don't. I'm sorry.
When you
All right,
came down to
question
court
was,
today,
what was he expecting to testify to today?
Objection irrelevant.
Oh,
I was expecting to come here and introduce the videotape and basically be done.
did you even expect to be cross-examined?
Maybe a question or two.
Objection, Your Honor. That's what expectation.
overruled.
You indicated that there was a report you prepared. Have you seen that report, sir?
Yes.
What is it? What did you put into that report?
Oh, objection, Your Honor. That's the report.
Sustained.
Yes, sir.
I'd like to mark this report, Your Honor. People's next in order. You have it.
617. And counsel, I'm sorry, excuse me a second. The videotape should be 1375, the people's, defense next exhibit. Ms. Clark.
Do you recognize that?
Yes, I do.
What is it?
It's a report I wrote on July 31st.
Does it contain anything about the substance of your interview, of the interview conducted by Hank Goldberg with Donald Paratus?
No.
What do you put into your report?
Objection, Your Honor.
Sustained.
What's the purpose of preparing that report, sir? Other than simply,
Objection, hearsay.
Finish the question.
was there anything substantive concerning the subject matter of the interview in that report, sir?
Objection, hearsay.
Overruled.
The only thing that I wrote of substance...
Objection is what he wrote.
No, the question, just answer the question. Yes or no, was there anything substantive?
Yes.
And what is that?
Objection, hearsay.
Sustained.
What is the purpose of that report, sir?
Asked and answered.
Overruled. Who wants to make the objections there?
Primarily just to document that I was there with DDA Goldberg and to...
No, I would object. The question was, what's the purpose of a report, not what was the purpose of this particular
Overruled.
report.
Overruled.
and to put into the record the numbers of the two tapes.
Numbers?
The sound lab, our sound lab, the District Attorney's Bureau of Investigation sound lab, gives an evidence number or their number to videotapes and audio tapes that we make.
And that's why you make a report, to document that?
That's why I did here, yes.
Now, you are aware, sir, are you not, that the defense has interviewed Donald Paratus?
Objection, Your Honor.
Overruled.
Yes.
And are you aware of exactly when that interview took place?
No, I'm not.
Are you aware that the interview occurred?
Objection, Your Honor. You already said he wasn't aware.
Sustained.
I asked exactly when the interview took place. You're not aware of when that interview took place?
No.
Were you aware of whether it took place before or after this videotaped interview on July 27th?
I'm not aware of it.
So, other than the fact that you know the defense did talk to Mr. Paratus, you don't know when it was?
Right.
Did you ask any questions of Mr. Paratus during this interview, sir?
No, I don't believe so, other than when it was sticking the needle back in the cup, not to stick me with it when I was holding it. I think I requested that.
You were holding the cup that he put the needle back into?
When he was drawing water during a demonstration.
And then you were holding a cup for him?
Yes.
When he put the needle back in, you asked him not to stick you with the needle?
I think something to the effect of be careful not
All right.
not to stick me with the needle.
All right, other than that request, did you direct this interview, sir?
No.
Did you have anything to do with determining what the content of the questions would be by Mr. Goldberg?
No.
Did you ask that the tape be turned off at any particular point?
No.
Did you ask that the tape be turned on again at any particular point?
No.
What were you doing there, sir?
It was my understanding when I went out that it was just going to be to document that it happened. To document it happened, it was going to be a videotape. It was my belief that I was just, if need be, I was just going to introduce that here and that it would speak for itself.
Do you expect to come here and be badgered like this by Mr. Neufeld?
Sustained.
All right. When Mr. Neufeld asked you questions during this half-hour break, sir,
Okay, okay.
can you describe his demeanor?
Hostile.
Okay. Look, we gotta stop for the day before she gets sanctioned. She's this close. And I don't know why, because he's the dick. Anyway. Guys, thanks for coming out to September 13th, Part 3, last part of OJ. And if you remember, it's the 14th, the 15th, and then boom, right to the 18th we go. All right, guys, I'll see you tomorrow. I hope you have a really, really good day. Behave, Bobby, and I'll see you soon. Bye.